the court to order.
Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Good morning. The COVID-19 pandemic has required many adjustments of the justice system. Social distancing and group size restrictions, as well as potential hardships on counsel of travel to Austin, do not allow us to hold argument in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may yet be glitches which will require patience. Otherwise, we will proceed in the same manner as we would in person. The arguments are being live streamed this morning, and a recording will be available later in the day. Court is ready to hear argument in 18-12-11, Innovative Block of South Texas versus Valley Builders Supply from Hidalgo County and the 13th Court of Appeals District.
May it please the court. Ms. Goldman will present argument for the petitioner. Petitioner has reserved 8 minutes for rebuttal.
Mr. Chief Justice, members of the court, and may it please the court. Valley Block's experts' quasi-Monte Carlo methodology lacks any modicum of reliability and gives plaintiffs every incentive to have an expert crunch arbitrary numbers unmoored to the facts and call it reputational harm. Valley Block's expert, Lair, testified that his calculations were supported by no data as to loss of reputation whatsoever, and that he selected random numbers out of the air to compute reputational harm. Under Texas law, as articulated by this court, juries, and no less experts, cannot simply pick a number out of the air and call it reputational damages, but that, by Valley Block's experts' own admission, is what happened here. If not rooted out, Valley Block's quasi-Monte Carlo methodology will equip any plaintiff to procure wholly speculative reputational damage awards based on an expert's bare ipse dixit. Aside from unreliability, the purported damages Lair calculated were exclusively special economic damages. Reputational harm is general non-economic damages. Pecuniary lost profits are special economic damages. Lair testified that to determine reputational harm, he calculated economic damages and the profitability that the business suffered due to defamation. His assessment contradicts this court's holdings in Waste Management and Burbage. Adopting Valley Block's measurement in defamation cases would open the door to double recovery, characterizing pecuniary lost profits as both special economic damages and general reputational damages. Okay. Lair repeatedly admitted that the numbers he crunched to derive reputational damages were random, based on no data, and grounded in no underlying analysis of business reputation. Lair admitted that he had no idea what the reputation damage is, much less what the statements were, who they were made to, or what impact they had. He explained that he had to take a random estimate because he had no idea if the reputational harm accounted for 1% or 99% of lost profits. He reasoned that going all the way up to 100% would sound silly, so he didn't do that. But he and Valley Block's counsel decided to stop the calculations at 60% of total lost profits so that his opinion would seem credible. Lair said that he didn't look at any historical data, samples, or comparable information when determining the lost profits due to defamation, because what's my sense of doing all that when all you need is sound judgment? And so he let his bare ipse dixit fill the evidentiary gap. Valley
Miss
Block,
Goldston, Matt, excuse me, but let's say if we do agree with you as to the quasi Monte Carlo method, what is your response to an argument that, putting that aside, that you would have to look at the business's lost profits to determine what the damage to the reputation of the business was?
sure. This court held in Waste Management and Burbage that evidence of lost profits and lost business value provide no evidence of the amount of reputation damages. This court in Waste Management rejected the argument that lost profits, expenses, and loss-based business are indicators that support estimates of reputational harm, and instead said that this evidence cannot quantify the amount of reputational harm. The plaintiff supported the damages claim in Waste Management with exhibits showing lost profits and expenses caused by the defamation. The court explained that none of these exhibits quantified any amount of reputational damages. Lost profits are not the sort of general damages that necessarily flow from a defamatory publication. Likewise,
what are those sorts of damages when it's a business that's being defamed? How would you, outside of this case, how in general would a business go about proving reputational damages?
okay,
And providing, you know, a number to the jury that so that it's not just putting something in the blank.
right. Well, I have a few responses to that, and it's a great question. Well, first of all, it's Valley Block's burden.
Ms. Goldman, wait just a moment. I think we've lost Mr. Cadell. And so we might ask Justice Busby to rephrase the question when we get him back on.
Sure.
I'm going to pause the timer, Chief.
Yeah. There he is.
Okay.
So I was asking Ms. Goldman, if, in general, not in this specific case, how would a business go about proving reputational harm? What sort of number could they present to the jury if it's not lost profits? How would a business go about proving harm to reputation and giving the jury a number to put in the blank?
Okay. Well, there are several ways that a plaintiff might go about it. A company might have a PR expert testify as to how the company's reputation suffered and what esteem might have been lost. Professor Dobbs' Law of Torts treatise says that considerations in assessment of reputational loss include: would the accusation tend to be permanent and have repeated effects? Did it reach a large audience or one especially relevant to the reputational issue? Was the accusation specific or vague? Did it touch highly emotional issues or charge serious departures from well-established and important community standards? You know, in this case, Lair ignored all of these criteria. He didn't even look at the statements or any possible impact on reputation. The reputational damages amount should not duplicate the amount of special damages, which is a separate category of damages. And of course, in this case, of course, and in every case, garbage in, garbage out applies here, just as it does everywhere else. Running calculations on worthless inputs yields a worthless result. And of course, I would also point out that reputational damages are non-economic general damages. Special damages are the economic damages, such as for lost profits. In Burbage, when the plaintiff tried to recover lost value to the business, this court explained that when the plaintiff seemed to seek damages to the business rather than damages for the loss of the business's reputation, and said that a business disparagement claim is the correct vehicle to protect the economic interests, not a defamation claim for reputational harm. Here, Valley Block used a measure of damages for the business disparagement claim that they dropped.
Ms. Goldman, did we say in the Anderson case that loss of business opportunity can support reputation damages for in a business disparagement case? And in this case, was there evidence of loss of business opportunity due to the defamatory statements? Is that more than a scintilla to support the jury's verdict?
So what this court held in Anderson, well, this court held in part in Anderson, that loss of business can support the existence of reputational damages. Of course, the evidence that the plaintiff has lost a job or business opportunities can evidence the existence of loss of reputation, but only if it is connected to the defamatory statements. So this can go to existence of reputational harm. And part of the problem that we have here is that Lear presumed, he took the total lost profits and just presumed that any random number might be attributable to defamation without looking at a single company or even the statements and what effect they may have had. Now here, we do
Why
have—
why isn't the Hinojosa situation some evidence of damages?
Okay, well, the Hinojosa statement, and again, this goes to existence of reputational damages, and Valley Block recovered $93,528 for lost profits, special damages due to the Hinojosa statement. And of course, Lear then said that that amount was also subsumed in his assessment. Hinojosa, I would remind the court, testified herself. Although she believed the statement, she said that it did not change her perception of Valley Block. She testified that she never thought Valley Block would knowingly use bad aggregate. In fact, she said she was planning to switch for just that one load for maybe a month or so, and she couldn't switch her business back to Valley Block for other reasons, such as scheduling problems with Valley Block. But she did not, while she did believe the statement, it did not affect her perception of Valley Block. It did not lower her esteem of Valley Block. And that, of course, this court held in Anderson needs to be shown, not only that the recipient of the statements believed the statement, but also that the perception of Valley Block diminished as a result. You don't have that for the Hinojosa statement. For the only other, there were 4 statements here. There's only even evidence on the impact of one of the other statements, and that's the first statement where the recipient, Stange, testified that he didn't even believe the statement and he refuted the speaker. The second statement was referred to in an email between 2 people who didn't even hear the statement being made to some unidentified customer. And then there's a third statement where, again, to a customer that was not a customer of Innovative, not Valley Block, and it was a statement about both Valley Block and another competitor, Pavestone. And of course, there's no evidence there of the impact that that statement had on the recipient, whether she believed it, whether it impacted her perception of Valley Block. And of course, all these statements are also about Valley Block's actual products. As Hinojosa said, she thought the product in that case the Valley Block's product may have been a problem for that one load, but she never knowingly thought Valley Block itself would use anything bad.
So is Ms. Goldman, is your argument basically on reputational damages that that Valley Block was trying to be too specific and their expert didn't get it right in trying to provide a specific number that was based on economics, so they shouldn't have gone that way looking at lost profits? But if that's true, then don't we have to back up and look at the record as a whole to decide whether there's more than a scintilla of evidence to support some amount of damages for reputational injury in order to decide whether the remedy here is a remand for a new trial or rendition of judgment?
There are a couple problems here. Not only, of course, that Lear looks at pecuniary lost profits, but that also his methodology was admittedly completely random and based on no evidence at all. And
but if we agree with you about that, then don't we have to look at the rest of the record to see if there's more than a scintilla of evidence of reputational damage in order to decide whether the relief that you get is a remand or rendition?
Well, the problem here is that there is no competent evidence. They use a totally bogus methodology, and Valley Block itself has completely pinned the amount of reputational damages which must be proven. There must be legally sufficient evidence of the amount of reputational damages. And Valley Block says that its evidence of that is Lair's testimony. It wholly hangs its hat on Lair's testimony. And that's, of course, because there's no evidence in the record whatsoever of any impact to Valley Block's reputation. They pinned their entire evidence of the amount of damages on Lair's testimony, yet he didn't even attempt to look at the statements or determine the harm caused. He had no clue about these statements, didn't look at historical data, samples, or any impact themselves. And there's no other evidence in the record trying to quantify the amount of reputational verbiage where the model is completely wrong, where it amounts to absolutely no evidence of the amount of reputational harm. Then there is no legally sufficient evidence of the amount of reputational damages. So,
Anything else?
oh, sure, sure. I have plenty that I'm happy to discuss with you all. In terms of, I can speak more to the quasi Monte Carlo methodology, which was a real problem here. Valley Block's assertion that this methodology called the quasi Monte Carlo exists in finance textbooks does not give Lair a pass to calculate a self-serving weighted average of 8 random numbers. Experts should not be able to use a quote unquote model as a veneer of credibility when there is admittedly no basis for the data that goes into the model. And courts have found this Monte Carlo, not quasi Monte Carlo methodology to be useful only when and if the data provides a known range. Of course, this Monte Carlo method, which is named after Monaco's gambling mecca, involves running millions of computerized calculations on evidence-backed data points to evaluate the most probable income. Lair's methodology is a caricature of this statistical methodology. Valley Block points to the Lyondell case, as does the 13th Court, to say, well, the Monte Carlo method has been accepted, but of course, there are so many distinctions. And of course, the key that here there's no known range of data. The expert in Lyondell used evidence-backed data points that the district court selected based on extensive documentary evidence to calculate and allocate responsibility between defendants in hazardous waste cleanup. And the Fifth Circuit cautioned that the Monte Carlo analysis is unreliable when injected with faulty inputs, and that we can gauge reliability by examining the input values. And I would also add that each alleged statement here at most disparaged Valley Block's product and did not support a defamation claim. We have from the 14th District in the Mayfield case from the Houston Court of Appeals that if the main complaint is a false statement directly injurious to business interest and the damage alleged and proved are limited to business losses, the claim may properly be considered business disparagement, although aspects of personal defamation may be incidentally involved. That's also supported by the Restatement Second of Torts, Section 623A, comment G. Lipsky explains that statements like here about the inferior or low quality of a competitor's product do not constitute defamation. Similarly, statements about bad product, bad materials, and bad aggregates are not defamatory in the sense of dignitary harm. And of course, the only damages that Valley Block requested are damages that would be recovered, special damages that would normally be recovered for business disparagement claims, yet it bypassed the pleading and proof hurdles of a business disparagement claim.
Any other questions? Thank you, Ms. Goldman.
Thank you.
We'll hear from the respondent.
May it please the court. Mike Cadell. First, let me start with am I on? It's not.
Yes, you're
okay.
on.
All right, thank you.
Yes.
First, let me start with the Lyondell case. I think there's a misrepresentation as to what happened in Lyondell. In Lyondell, the court first specifically stated the Monte Carlo simulation is not inherently untestable. Courts routinely admit statistical evidence, and we can gauge reliability by examining input values and requiring transparency from testifying experts. What happened in this case was exactly what the Lyondell court suggested could be done or should be done with the Monte Carlo analysis. The input values were revealed by the expert. There was complete transparency from the expert. The difference between in the Lyondell case, there was some evidence, and in fact, the court had to project 3 input values, and the first input value was a low range, there was a mid range, there was a high range, but it required some interpolation by the court before it could reach those ranges. Then they gave it to the expert. In this case, our expert, Dr. Laird, did exactly the same thing. He looked at the evidence, and I think it's important for the court to appreciate that the innovatives' very careful wording, they parse the language when they say Laird admitted he had no data as to reputational damages. That's what he said. That doesn't mean he had no data. And so they're very careful in parsing that to say as to reputational damages. He had a lot of data. He looked at, and it's uncontested in this case, that Valley Block was in business for over 60 years. More than 50 of those, it was profitable. It's uncontested that Valley Block went out of business only 3.5 years after Innovative began operations. It's uncontested that the president of Innovative instructed his sales force that we were going to put Valley Block out of business. It's uncontested that the sales manager for Valley Block, that they instruct their salespeople to tell people that Valley Block used bad material, that they had a bad product, and that if they didn't tell people that and they didn't get the business, they would not get paid. It's uncontested that the defense makes it sound as though there was, or the petitioner makes it sound as though there was only one letter and one statement. In fact, the evidence is from the sales manager that there were numerous letters that to customers, potential customers in the Valley, with respect to Valley Block using low quality aggregates. There were numerous instances when customers were told that Valley Block used bad materials and had a bad product. They even had a testing machine where they would buy low quality Mexican block, test that before a customer, and then it would be crushed and the customer would say, wow, Valley, and they would tell the customer, that's Valley Block's product. And and then the customer would say, wow, that's really bad product. The Steve Stang, who testified that he was shown occasions over an intervening period of about a year, photos of Valley Block's coal pile, their discards, their seconds, and told that that was Valley Block's primary product. He said he was under the distinct impression that they were going around telling other people the same thing. So
Mr. Cattell, I mean, what is the basis for him coming up with these percentages that do not seem to be based upon the evidence? When you look at the Monte Carlo model, first of all, those scenarios typically are run millions of times. This scenario was run twice. In the prior case, it was used to determine where a fire is going to occur. This is simply to figure out what percentage of the loss was attributable to this action. So where does that come from? Where's the basis for that?
Right. First, Your Honor, it's important, and I appreciate the question because this is an important distinction that's been glossed over by Innovative. The textbooks, we went in the Daubert hearing and then in the courtroom, we went over numerous textbooks. In the Daubert hearing, we had about 14, and the Daubert hearing lasted over 3 hours. In the courtroom with the jury, we still had 3 textbooks, and we also had an article just explaining the distinction between the Monte Carlo method or the standard, the original Monte Carlo method, and the quasi Monte Carlo or modified Monte Carlo methods. There are textbooks that we used in the courtroom that are titled the Monte Carlo methods. There were articles written where it's talk about the quasi Monte Carlo method. And the reason for that is in a situation like this where there are few variables. And it's important to appreciate that in this case, not once, never has Innovative ever challenged the variables, the factors that were identified by Dr. Lair. Even today, they have not challenged those factors. Dr. Lair said he surveyed the market. They make it sound like he did nothing. In fact, he looked at the economy. He looked at interest rates. This is all in his report. He factored in the recession. The recession started around October 11th, 2008. This process began in 2006. Nonetheless, he factored in the fact that the recession may have had a role in this. He factored in that Valley Block had certain financial issues, although he said their financial condition was strong. He factored in that Innovative was in fact competing at a low price. So there was legitimate competition in addition to this defamation. He factored in the weather and said, okay, when you look at all these factors, and again, Innovative has never challenged that any of these factors were inappropriate. Never have they suggested that there is some other factor that he should have considered. So you only have these half a dozen factors for what could have explained Valley Block's demise in 3.5 years after Innovative began business. Then you have only so many, you have a fixed number, and I don't know how you calculate damage to reputation for a business unless it is somehow tethered to the lost profits for that business. Otherwise, we have a waste management situation where the president says, our reputation is priceless. And then the jury awards $5 million and the court found there was no evidence. So you only have so many factors here, and then you have to allocate those with both likelihood of occurring and the probability and the percentage that they contribute to the demise of Valley Block. And this is where the Monte Carlo method, the modified Monte Carlo method, and we went through this at volume 5 of the trial record, pages 73 to 92. We went through this in detail with the court and with the jury and read through and walked through articles, treatises, things of that nature. So when you have a situation where you have few variables, in fact, an expert is supposed to exercise, rather than just simply doing random numbers, the expert is supposed to exercise some judgment in what would be an appropriate number. And then the term pseudo-random, they've turned it into a pejorative term, but in fact, it's in the textbooks, it's in the treatises. It's pseudo-random in order to have an equitable distribution. So if you did a small sample, or you did and you replicated it, say at 10 times, the reality is you might get 10 times where the probability of Valley Block being damaged, its reputational damage being 90%, it might turn out that just pure probability, 4 or 5 of those times might be at a very high level. So what Dr. Lair did is he used his judgment to say, no, given these factors, given the recession, given the legitimate competition, given financial condition, given interest rates, given the threshold, the fact that there is limited competition in the value, I think that the most that you could say, you could ascribe to Valley Block's demise arising from this reputational damage was 60%. And then you have to say, what's the probability of that? And he said at an extreme, only 18% that's a possibility. Then at the low end, he said there should be, given this evidence, it's about 15%, that at least 15% of Valley Block's injury, its damage, was a result of this reputational damage. And even that though, he only ascribed to a 20%. Now what the Lyondale court tells us is, as long as you have transparency, and as long as you can examine these inputs, then that is a legitimate court. As the court said in Lyondale, we admit statistical evidence all the time, and we gauge reliability by examining input values and requiring transparency. Dr. Lair had complete transparency and had what Innovative has chosen to do. And of course, they did not challenge the admissibility of his testimony at trial. So now they are left with arguing that he had zero credibility. That's their only option in order to avoid that there be even a scintilla of evidence. When in fact, when you look at his report and you look at his testimony in its entirety, what you find is he took a very reasoned approach, and he did not, had he done the simulation, in fact, some simulations would have had 90% of the damage to Valley Block being due to the reputational harm created by these defamatory statements. He didn't do that. He actually took a conservative approach. And so the lost profits for Valley Block, which were never challenged, his calculation of lost profits for Valley Block for the period in question, the $5.1 million, they were never challenged at trial. They were never challenged at the 13th court. Now, for the first time, after we have pointed this out, it wasn't challenged. It wasn't challenged in the petitioner's application. For the first time in the petitioner's brief, in footnote number 2, they say, "Oh, he got that wrong." It's too late for that. So that's unchallenged. These statements are unchallenged. His inputs were unchallenged. His factors were unchallenged. So what he did was he used his own judgment, and we went over with the jury, and there was an article, a specific article, which said the expert should not abandon his sanity. So when you're doing a quasi Monte Carlo or a modified Monte Carlo, where you only have a few values and a few inputs, then you have to exercise your reasonable judgment. And that's what they should have engaged on. What they've chosen to do instead is just engage in this sort of hyperbole attack on Monte Carlo, which when it's a methodology that's been used, that's in numerous textbooks, that's taught regularly in school, in universities, it's employed by government, it's employed in many different facets. And so there's nothing new here. So we go beyond what was done in waste management. I have to say, it is ironic that they cite to Burbage a couple of times, because in fact, the Burbage court, this court, found that there was no evidence of actual damage, actual injury in the record in Burbage. So we have multiple instances. The Sanchez, the sales manager for Innovative, said the lies and the deception and the cruel sales tactics, stuck with him, and he found it hard to sleep at night because of what they had done by putting Valley Block out of business. That's their sales manager, the defendant's sales manager.
Mr. Cadell, let me ask you, switch over to the 93,528 that was awarded for actual pecuniary lost profits. As you know, defamation and business disparagement are two distinct torts, and you did not submit the business disparity claim in your charge. So what does that do to your recovery?
Well, I think we have to look at Lipsky. So Lipsky was a case where there was a natural gas drilling company, and
we've lost you, Mr. Cadell. Let's wait a minute, see if we can get him back. There he is.
But he seems to be muted.
Right.
okay, hold on.
Okay.
Can you hear us, Mr. Cadell?
Now we
Yes.
can hear you.
Yeah. Okay,
Um,
Justice Lerman had a
The
question.
Lipsky case.
I was basically asking you,
Good.
can you hear me?
Yes, I can. Yes, Your
That
Honor.
the manner in which this was submitted to the jury, simply because you did not present, you only presented the defamation claim. What does that do to your special damages award?
Correct. Well, two things. First, this is the Lipsky case. It was not an attack on a single product, it was an attack on the company. The company uses bad materials. The company makes bad products. The company uses low quality aggregate. They would show block and crush it, and it was Mexican block. And they said, that's Valley Block's block, which made them, they attacked the integrity of the company. And ultimately the company was put out of business. They didn't lose a product. They lost the company. So what does this do for special damages? It means that we did, and I apologize, Your Honor, but my recollection is that under business defamation, you can seek both special damages and general damages if you have defamation per se. And what we did was we sought special damages for the Ram Masonry contract, Cynthia Hinojosa, and then we sought the general damages to reputation, and that was Dr. Lair's presentation, his opinion. So I don't see, and I don't want to lose track of my time, I don't see
You have 10 minutes, Mr. Cadell.
oh, there it is. Okay, all right, thank you. So again, returning to this evidence far exceeds what there was in Waste Management, in Burbidge, Brady, Anderson. A couple of things quickly. The reason the Innovative makes it sound as though there was only one letter, that sort of thing. The reason that we only have a handful of these letters and memos is Innovative never turned over any documents to us. None of these documents. We're fortunate, they claim that their computers changed over and that they lost all of their documents. So we had nothing from Innovative. What we were able to get was from John Sanchez, who when he left the company, took a handful of documents with him and thankfully had these. But for that, Innovative's Mr. Riegert's testimony when we took his deposition was they never did anything like this. He never sent a letter. He said we wouldn't do business that way. So the reality is we were fortunate to have Mr. Sanchez. Finally, let me say this. The sky is not falling. There is conflict in the courts below. And makes much of the fact that this is the only instance of a Monte Carlo or quasi Monte Carlo method ever being used in the Texas courts. How can this be a case that presents a question of law that is important to the jurisprudence of the state? So we think this writ should be dismissed as improvidently granted, as the court has done in the past. I don't think this open the floodgates to Carlos Simeon, but it does. If there are those, then the court can set standards for that at the appropriate time. In this case, this was subject of a lengthy Daubert examination and then subject to an extensive presentation at trial where they did not object to the admissibility of his testimony.
Any other questions? Thank you.
Unless the court has any other questions, that's all.
Thank you, Mr. Cadell. Ms. Goldman, we'll hear from you on rebuttal. There she is.
Oh. Okay. Excuse me. Just pardon me, I'm having some technical difficulties.
We can hear you and see you.
Okay, well, that's good to hear. That's good to hear. Okay, I have, thank you, Your Honor. May it please the court. There's several points here, and I'll of course answer any questions that the court has. First, I'd like to clarify that Innovative did object to the admissibility of Lair's testimony. before trial in a Robinson-Dalbert motion, at a Robinson-Dalbert motion hearing, and during trial on a motion for directed verdict. And of course, in post-trial briefing and on appeal, the court did deny these motions. And cites for that are the Clerk's Record, Volume 2, page 571, the Reporter's Record, Volume 3, pages 74 through 81, as well as page 85, the 5th volume of the Reporter's Record, pages 236 through 238 and 244. We've also repeatedly challenged both the admissibility and assessment and calculation of total loss profits. A few points to respond to. Valley Block's counsel points to Lyondell, and it emphasizes the language that under Lyondell, it's important and critical to gauge the reliability by examining the input values and requiring transparency, of course. Also, Lyondell made very clear that the data needs to provide a known range. Here, Lehrer was transparent. Valley Block's expert was transparent that his input values were revealed. He revealed his input values, and he also admitted that they were completely unmoored to data. He said he had no idea what the reputation damage is, much less what the statements were, who they were made to, or what impact they had. He said he didn't even look at his...
Mr. Cadell said that you don't disagree with the factors, the 6 or 7 factors that he looked at before he did the calculation. Is that true?
No, I mean, no, we absolutely objected to his testimony, his calculations. And, you know, in terms of factors, it's interesting, you know, they say that Lehrer discussed many factors for lost business, as he did, such as recession, innovatives, lower prices, competition, and weather. The problem is that none of that has anything to do with the statements themselves or their impact. Lehrer testified that he had no idea as to the actual reputational loss or even the statements themselves, and he did not try to figure out whether the cause of loss was defamation or anything else, which cause of loss was more probable. And this court held in both Burbidge and Hancock that the inference regarding the defamation must be more probable than other inferences. Lehrer didn't even try to start to figure out what impact the defamation itself actually had. Like Burbidge, the record here, like Burbidge, where the court held that customers of cancellation of business was not evidence of loss of reputation because the cancellation could have occurred for any number of reasons. That's much like here. And, you know, I'd also point out that, you know, aside from, you know, first looking at total loss profits, you know, even if using the total economic damages for the years in question were not fatally flawed, Lehrer's methodology would still fail because steps 2 and 3, picking these 2 sets of 4 random percentages of lost profits and calculating a weighted average of each set by giving each random percentage of likelihood of occurring, was based on nothing more than his own say-so. I'd also like to note that, you know, now Valley Block's counsel tries to point to a few pieces of extremely vague testimony, such as Sanchez's statement. You know, he says Sanchez testified. Yeah, there's some statement that it worked to a certain point. That's it. You know, like Burbidge, the record here at best contained only vague testimony on the actual impact of the defamation. Valley Block suggests that similar letters were sent to other customers, but none of these letters were offered into evidence, nor were the purported recipients of such letters identified, much less any evidence of their actual, whether they believe the statements, whether it changed their perceptions of Valley Block. And also, since it's undisputed that Stange did not believe the first statement, Valley Block now asserts that innovative, regularly misrepresented, poor quality block is produced by Valley Block. But again, there's no evidence of the identity or reactions of the purported recipients of such statements. So again, you know, even the testimony that they're trying to look at now, it's all completely vague. It's all completely vague. And of course, they've done nothing to try to quantify the amount of reputational damages. They haven't even looked. They have provided zero evidence of any amount, any actual impact, any on any customer who actually possibly believed a single statement here, or aside from believing, which they might have from Hinojosa, no evidence of a customer actually having a lowered perception or esteem of Valley Block. Now, apparently Valley Block really wants to look at the lost profits, and it wants to pin the amount to lost profits. And of course, Lair for reputational harm, and of course there are many problems with that. For one, we've discussed Waste Management and Burbage, which state that these are not indicators of the amount of reputational harm. These do not quantify the amount of reputational harm. And of course, general damages and defamation cases are non-economic damages, while special damages are for lost profits. Lair repeatedly testified that he solely calculated pecuniary lost profits and economic damages. The real problem that Valley Block has here is that they decided to drop their business disparagement claim. And they also talk about
Ms. Goldman, on that point, didn't we hold in Anderson that you can also recover special damages for defamation?
Special damages, yes, special damages can be recovered for defamation. If
Okay, so why aren't the damages that were awarded for the Hinojosa contract special damages that are recoverable for defamation?
Right. Now, in defamation cases, there is the possibility of also recovering special damages if it's, with pleading and proof, and there was pleading on the Hinojosa statement. But again, the problem here is that they're asking for double recovery. So now lost profits become both special damages and reputational harm. And aside from that, the problem with the Hinojosa statement in particular is that she testified that the statements did not impact her assessment. And at most, the loss of business could show some, if tied directly to the statement, can show evidence of reputational harm if perception is lowered. I think someone might have a question. No. Okay. I didn't want to interrupt anybody. Lair's unreliable quasi-Monte Carlo analysis really threatens to wreak havoc on Texas's damaged jurisprudence, particularly in defamation cases. Under this methodology, a billion-dollar company that went bankrupt could sue a competitor for business reputation damages equal to only 20, 40, 60%, or whatever number an expert wants to pick out of a hat of total loss by making up numbers and then running them through this quasi-Monte Carlo analysis. This court should denounce this quasi-Monte Carlo methodology before it has a chance to gain a foothold in Texas law. Unless the court has any other questions, we respectfully ask that the court reverse the compensatory damages award.
Any other questions? Thank you, Ms. Goldman. The case is submitted. And that will conclude the arguments we have for this morning, and the court will adjourn.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned. Thank you so much. We appreciate it. Really appreciate your help and your cooperation. Take care.
Oh, he's muted.
Casey, stop the stream.